Federal district courts have jurisdiction in all cases, quote, arising under the Constitution, laws, and treaties of the United States. This means that if two parties have a dispute concerning federal law, for example, a patent dispute, patent law arises under federal statute, or the Constitution, for example, free speech under the First Amendment, these cases can be heard in federal court. Why? Why do we allow arising under jurisdiction? There's a presumption that state courts will be hostile to federal rights, not give them full force. Also, we want the federal courts, as opposed to state courts, to be able to adjudicate the fine points of federal law and basically decide what the federal law is going to be. But this does not mean that state courts are deprived of subject matter jurisdiction over arising under cases. State courts are typically courts of general jurisdiction, which means they have no limitations on their ability to hear cases, and if they do, they're typically very narrow. Arising under cases are no different, which means that arising under cases can be heard in both federal and state court. It's the plaintiff's choice to decide whether he's going to go to federal or state court to hear his federal dispute. Where the federal courts have jurisdiction, such as arising under cases, be aware of the defendant's right of removal, which we're going to discuss later. There is one noteworthy but relatively minor exception to the general rule that claims involving federal law can go to federal court: full faith and credit clause cases. As a reminder, the full faith and credit clause says that when a state court issues a judgment, other courts have to enforce it and honor it. Even though the full faith and credit clause is part of the federal Constitution, you cannot use it independently to create federal jurisdiction. As an example, Jack sues Jill in Mississippi in state court on a state law issue and wins, and now wants to enforce that victory for some reason in Massachusetts federal court, using the full faith credit clause as his basis for jurisdiction. Because the lawsuit really arises under state law, the full faith and credit clause merely requires the federal court to listen to state law. There is no real federal dispute, and the courts are not going to assume arising under jurisdiction. But basically, in every other case, if you have a federal statute, a federal treaty, or a provision of the Constitution, there is going to be federal jurisdiction. Now let's say you have a suit that combines federal and state issues, and the state issues predominate. We're going to discuss supplemental jurisdiction later, but very briefly, is the inclusion of a federal issue enough to create federal jurisdiction over the dispute? Generally, believe it or not, yes, even if it's relatively minor, but only if the federal issue is not patently without merit, completely frivolous. So if you have a massive complex tort suit, a state law claim typically, and throw in a Clean Water Act claim related to the same facts, you can probably get into federal court to adjudicate the entire dispute, even though the Clean Water Act, a federal statute, is a subsidiary claim, as long as it's not frivolous, as long as you have a basis for winning on that particular claim. Next, we're going to move on to diversity jurisdiction.